I would like to begin by talking about what is perhaps the most glaring recent example that forces us to question the fetters on judicial independence in India, which is the entire episode that played out in the Delhi High Court during the horrific violence that gripped India's national capital in February 2020. The violence in Northeast District of Delhi was preceded by days of incendiary speeches and open calls to violence against anti-CAA protesters, mostly targeting Muslims, by senior members of the ruling BJP, including a union minister, Anurag Thakur, and elected representatives like Kapil Mishra and Parvesh Verma. As the violence escalated, the High Court of Delhi on 26 February 2020, while hearing a petition seeking the registration of a first information report against these BJP leaders, asked the Delhi police to take a conscious decision to register FIRs in 24 hours. Justice Muralidhar, who was then leading the bench, expressed his anguish that the city is burning and questioned the Delhi police on its delay and its lack of acknowledgement of the hate speeches as crimes in themselves. The Solicitor General of India, appearing for the Delhi police, repeatedly asserted that FIRs will only be registered at an appropriate stage. On 26 February, the Law Ministry published a notification transferring Justice Muralidhar from the Delhi High Court to the Punjab and Haryana High Court. While the transfer order was preceded by an earlier decision of the Supreme Court Collegium, its timing was nothing short of suspicious. The Campaign for Judicial Accountability and Reform had remarked in a statement then that the rushed manner in which the transfer was effected cannot be ignored, and that the transfer was not done in public interest, but only with a view to punishing an honest and courageous judicial officer for simply carrying out his constitutional duties. On 27th February, the matter was reverted to a different bench, and the court gave the government 4 weeks to file a counter in response. To date, no FIR has been registered against these BJP leaders. Instead, as we've heard before, in subsequent months, the special cell of the Delhi police began detaining and arresting a large number of students and activists, many of whom have now been incarcerated for over 2 years. Most of those arrested are young Muslims who had become prominent voices against the controversial Citizenship Amendment Act of 2019. And the thousands of pages of the charge sheet filed against them largely includes details of their participation in the anti-CAA protests, with virtually nothing connecting them to any actual conspiracy concerning the riots. Last year, the Delhi High Court had granted bail to 3 of the 18 accused, Jamia Millia student Asif Iqbal and members of a feminist collective, Natasha Narwal and Devangana Kalita, citing the absence of any material evidence against them. However, the Supreme Court blocked the release of any of their co-accused arrested under similar charges by ruling that the Delhi court's decision could not be cited as a precedent. Courts in India have historically given a wide latitude to state agencies to arrest and incarcerate people in the name of national security concerns, especially when those being accused come from minority or marginalized communities. This has especially been made possible by India's vast array of anti-terrorism laws, the latest iteration of which is the Unlawful Activities Prevention Act, or the UAPA. The law severely constrains an accused's right to obtain bail and allows for prolonged incarceration as the case meanders its way through the courts. Judges are only allowed to give bail to an accused if they are satisfied that no case is made out against them prima facie or at first glance based on evidence collected by the police. It is different from ordinary criminal procedure, and the Supreme Court has further restricted an accused's chances of getting bail when it ruled in the Zahoor Ahmed Watali case in 2019 that courts could not look into the quality of evidence placed before it, but only on whether or not some evidence had been collected against the accused. The Supreme Court has effectively made broad probability rather than a determination of evidence as the basis of seeking bail under UAPA. These laws have led to several instances of unjust incarceration over the years, with one very glaring recent example being the Bhima Koregaon case, about which Reverend Sarah was just talking to us. and in which Father Stan Swami was imprisoned, as well as 13 other human rights defenders continue to be in prison. In February 2019, a US based forensic investigation firm called Arsenal Consulting found that one of those imprisoned in the case, activist Rona Wilson's computer, was hacked using malicious software to plant 10 letters, which the NIA as well as the Pune police have used as primary evidence against her, justifying her arrest. Follow-up reports in subsequent months found that evidence was fabricated in a similar way against at least one other accused, senior lawyer Surinder Gadling. Despite these reports being filed before the courts nearly 3 years ago, the courts have refused to consider this fresh evidence to grant bail, much less to reevaluate the entire case, which obviously seems to be based on flimsy and fabricated grounds. Another worrying development in recent years has been the increasing use of so-called sealed cover jurisprudence, where the Supreme Court as well as lower courts accept evidence filed by state agencies under a sealed cover that is not shared with the accused or with other parties. This practice goes against the basic principles of natural justice and the Indian Supreme Court's own decisions that make the disclosure of all documents with the accused a constitutional mandate. It was heavily relied upon by the Supreme Court in the National Register of Citizens case concerning the state of Assam, which Dr. Kennedy was talking about, in which the court validated the exclusion of as many as 1.9 million people, mostly belonging to the minority Bengali speaking as well as Muslim communities in Assam from the citizenship rolls. It has also been used in many politically sensitive cases, such as the disputed purchase of Rafale fighter jets by the Indian government. Recently, the Kerala High Court also relied on sealed cover evidence provided to it by the Home Ministry to justify the ban on Media One TV, India's only satellite TV news channel that is run by a Muslim management. In a welcome move, the Supreme Court last week placed a stay on the ban, signaling a discomfort with the increasing use of sealed covers. However, until such time as the Supreme Court positively prohibits this practice that has evolved in its own chambers, it continues to be a dangerous weapon that allows the state to skirt public accountability in a judicial forum and raises uncomfortable questions about judicial independence. While Indian courts' reluctance to protect civil liberties in the face of government claims of national security has an unfortunate history, a more recent worrying phenomena has been its tactic of delay and virtual abrogation of responsibility in matters concerning the political agenda of the ruling party. The clearest example of this are the Citizenship Amendment Act, which many decry as unconstitutional, and the abrogation of special status given to the state of Jammu and Kashmir, both of which have been challenged before the Supreme Court, but have been pending without adjudication. Dr. Kennedy already spoke in detail about the CAA, so I won't go on about it. But the one thing that we do need to highlight is while the Act allows people who have been found to be foreigners to be deported, the truth is there is no way to deport them. There's no evidence of them being Bangladeshi nationals, as the state claims, and the government of Bangladesh has repeatedly said that it's not ready to take them in. And what it does, what the NRC process has done, and the entire foreigners tribunal process does, is essentially it renders people stateless in their own homes. It reduces them to a bare existence without rights. Before concluding, we cannot fail to mention the recent Karnataka High Court judgment that paves the way for barring hijab-wearing women in educational institutions. We can have a debate over the desirability of the hijab or over how or even why the Karnataka High Court concluded that hijab is not essential to practicing Islam. But we cannot forget that at its core, this is an issue of access to education and specifically the access to educational futures of these Muslim women. The court's complete disregard for how its decision will impact the educational future of thousands of Muslim women and their access to public institutions is the most unfortunate part of the judgment. While many might call us anti-national for speaking about these issues in a public forum, it is precisely our sense of patriotic duty that constrains us to speak. Courts in India are the guardians of our constitutional order, and it is the citizens' faith in the judiciary as an independent and fair guardian that sustains trust in the larger system. In a time of increasing majoritarianism in this plural and diverse country, we hope that the courts will look inwards and reclaim their role of protecting democratic rights and fundamental freedoms of its citizens. Thank you.